Every day in the USA, people find themselves in court.
All right, Mr. Stickley, thank you for joining us. This is People versus Trevor William Eugene Hewitt. Mr. Hewitt was placed on probation on a charge of attempting to obstruct a police officer and domestic violence. Placed on probation in January of 2023. Mr. Hewitt, the allegation is that you have violated your probation by failing to pay fines and costs, failed to abstain from the use of alcohol or drugs, or failed to submit to a test upon demand of any police officer, failing to participate in treatment program as directed, and failing to abstain from assaultive or threatening behavior. Those matters were alleged that you have violated your probation. One of the most concerning things in this petition is the allegation of continued assaultive or threatening behavior. And now there's a probation violation that, a PPO violation that also causes me concern.
He just really hasn't done anything he's supposed to do or gotten a job or anything like that. And then we had the incident on July 6th in Sturgis, which last I knew there was an open warrant for the police, but the prosecutors hadn't gotten it yet. So I don't know where that stands. But at that point, Ms. Harmon had stated that she did want to press charges for that incident. And then now we have this PPO.
Do what?
Yes. There was an alleged assault of Carly Harmon in Sturgis on July 6th. You haven't been doing your treatment. You haven't been doing your testing. And there's this new other assaultive behavior. And you haven't found a job in 6 months. You haven't gone to your
I work 7 days a week. Dan, you know I work at Fawn River Kayak 7 days a week, man. I told you that.
All right.
I was supposed to be at work
right.
yesterday.
So
hang on.
All right. So you're working at Fawn River Kayak?
I got CMH scheduled for today. I was supposed to go into CMH today. The whole thing with Carly, she keeps asking me to, it doesn't.
Hang on, stop. You can't get into that yet, sir.
Yeah.
This is in the public record. Daniel, your probation agent, says the staff at DHS and Community Mental Health are very afraid for their lives and the lives of Carly. She keeps going back to him despite the abuse and threats. He has told staff he will kidnap Thomas and bury agents in the woods. He has constant threats of killing and burying his therapist and DHS staff. CPS also indicated they were going to pay for the group. So we will delve into that further, but you're a potential threat to others. So bond is canceled. You haven't done anything you're doing. Daniel's recommending 112 days. Working at a kayak rental place doesn't qualify as for doing any of the treatment or other things, including testing I had ordered. It's interesting you were never able to afford testing, but you're working 7 days a week. Anyway, your bond's canceled. We'll appoint counsel for you and set this for a hearing. I am concerned about the safety issues and we'll follow up on your mental health appointments. But right now, you're scaring them. All right.
I had CMH.
Here comes Miss Davis. Good morning, Deborah. Thank you for joining us on short notice. This is file number 22181963FY. Getting to the point where I'm going to have to start wearing cheaters or something, but I've made it this far. In this instant case, the defendant is Trevor William Eugene Hewitt. He was charged with domestic violence and attempted resisting obstructing a police officer. Mr. Frazine has prepared a probation violation allegation and a status report. The allegation is that you violated your probation by failing to pay fines and costs, failing to abstain from the use of drugs or alcohol or submit to a test on demand, fail to participate in treatment program as directed, and failing to abstain from assaultive or threatening behavior. All right, anyway, the allegation, and any one of these could be a basis for a probation violation. Failing to pay fines and costs, that's the one I'm least worried about. Failure to abstain from use of alcohol or drugs or test on demand, failing to participate in treatment, and failing to abstain from assault or threatening behavior. Those are the ones that are cause for concern. Mr. Gibson has discussed this with his client. At this point, Mr. Gibson, you've advised that your client wishes to have a hearing regarding this.
Yes, Your Honor.
Mr. Gibson, does the defendant wish to testify?
I believe so.
Absolutely. Mr. Hewitt, why don't you come up to the witness stand here? Mr. Gibson?
Is it correct that you were placed on probation on January 11th, 2023?
That is correct.
You understand that you're here today because the probation agent has indicated that you have failed to live up to the terms of probation and have violated the terms? You understand
That's what I'm
that?
accused of, yeah.
Okay. So with regard to the payment of fines and costs or financial obligation, do you recall making any payments to the court during the term of probation?
No,
Now, were you employed during the entire term of probation?
no,
So is it correct that when you first got on probation, you were still, I guess you could say, injured and maybe not released for work because of a prior work accident?
that is correct. I had a titanium plate and 8 screws in my left foot. Got removed in May
In May of what year?
this year.
Okay. So until that stuff was removed, were you available to work?
No,
So once you were cleared to work, did you make efforts to find employment?
yes.
And when did you begin that process?
Immediately shortly after I had the plate removed. I had
Okay,
a 3-week healing process and
so probably either May or June of this year.
yeah.
And then did you get a job?
Yes,
Or where was that at?
on a kayak.
So when do you believe you started working there?
I'm not really sure. That was just like a spur of the moment kind of thing. I can't remember the day I started.
Okay. How long did you work there?
Up until the date of the arrest.
Okay. So if not for your arrest,
I'd
you
still
would
be working there.
still be working there, you
I got
think?
arrested in a Fawn River kayak shirt.
Okay. How much were you being paid at Fawn River?
$10 an hour cash.
Okay. And you were working a lot of hours there?
7 days a week from 8 to 6, and Saturday and Sunday I'd work until 9.
Okay.
Really a quarter to 8. Get there at 7:45 every morning.
Did you tell your probation agent, Dan, about the job there?
Yes. He confirmed it. My boss Jeff came to me and he told me that somebody named Dan called and asked if I worked here, and he said, yes, I work here. And that was it.
So do you recall that at times during your probation, you were asked to submit to a drug test?
Yeah. There was one time when I was living in the Meyer parking lot of Three Rivers, and I had told him that, I'm barely getting by right now, and he said, I understand that. I believed it was excused. The one time that I was available to test, I was at work, and I had to talk my boss into letting me leave. He had to run into town, and when he came back from town, he let me go.
And did you test that day?
Yes, sir.
Do you remember what the date was?
No. Last month.
So was there ever a time that you were asked to test and that you told Dan you couldn't?
Because of financial ability, the one time.
Was that a day that you told Dan that you were struggling with sobriety?
Possibly, yes.
When you would tell Dan that you were struggling with sobriety, would you give him any more details, like admit to using controlled substances?
You wouldn't ask. You didn't ask for specific detail. My point of view was Dan was really, I don't know, I thought I was doing all right, man. We had a lot of conversations about his house being built by Champion Home Builders and me working for Champion Home Builders and stuff, so.
Do you recall an incident where you were accused of going to the work of Carly, and that you were accused of threatening her at her work?
And what day would that be?
I believe it was at Applebee's in April.
The cop was dispatched, the police officer.
It was in the end of April, beginning of May 2023 at the Applebee's in Three Rivers. Do you recall an accusation that you had threatened Carly that day?
No, nothing about threatening her. Went to her work one day and she snatched my key fob out of my truck and ran inside. My truck was basically stranded outside of Applebee's until one of her coworkers called the cops, and the cop came and made her give me my key back after running the tags and registration on my truck and it coming back in my name. He came out and said, "It's obviously your truck." And I said, "Yeah."
Did you go to Applebee's to see her that day, or did you just happen to be at Applebee's?
Of a request from her to go pick up food, probably. She fed me. She worked at Applebee's. She gave me food.
Since you were placed on probation, have you threatened Carly Harmon in any way?
Absolutely not.
Were you ever physically assaultive toward her after you were placed on probation?
Absolutely not.
There's an allegation that she was punched in the arm by you since you've been placed on probation. Did that occur?
Today is the first I'm hearing about that. I never talked to Hopkins about that. I've had quite a few run-ins with Detective Hopkins, and that wasn't one of them. One since I've been released from prison was a Tiffany situation. Neither here nor there. My phone number hasn't changed since I've been out of prison though, so I think it would be very easy for the Sturgis Police Department to get hold of me.
You're accused of threatening DHHS staff or pivotal staff or making threats in their presence. Do you recall that?
Last year, not since I've been on probation, no. I haven't really had any run-ins.
So did you make any threats since you've been placed on probation to anyone from the DHHS staff or pivotal?
Absolutely not. I've had one meeting with Heather since I've been on probation. I haven't talked to any other CPS workers or anything. I haven't communicated with any of them.
Do you recall that you were asked to participate in a treatment program as part of your probation?
Yeah, the DV class.
Did you participate and complete that?
No, I had numerous occasions where I talked to Bill from the DV class, and it was arranged eventually. Every single penny I've been making has been gone to Carly. She wouldn't have her apartment if it wasn't for me. I paid for a deposit on her apartment. I paid for everything. I paid for gas to get her back and forth to work. I paid for gas to get her to her drug testing. I paid for everything. So no, I haven't been financially able to pay for anything. She wouldn't have her awesome apartment if it wasn't for me.
Now, it's indicated in the probation agent says that at some point during your probation, you had indicated that you were going to be moving to the Detroit area.
I did.
Okay, so
Sterling Heights.
when did you move to Detroit?
I don't recall. I just packed up my stuff and left.
And that was during the term of probation?
Yes, sir.
Did you let your probation agent know?
I believe. Maybe, I don't remember.
Okay.
I don't believe I had any intention of ever coming back, so more than likely not.
So how long were you in Detroit?
Over a month.
And then you did return?
Yeah. Sadly.
So at the time that you moved to Detroit, your intention was to stay there and never come back to this area?
Yeah, get gainful employment because I have a Champion Home Builders like 15 minutes away from where I was staying in Sterling Heights.
Did you make any steps to start a probation transfer or anything along those lines?
Wasn't there long enough.
Now, on or about June 30th of 2023, it was alleged that you had told your probation agent that you were going to the Coldwater Psychiatric Hospital, and that he told you when you get there to sign a release. Did you go to the Coldwater Psychiatric Hospital?
Yes. I'm not aware of any release though.
Were you there then? Did you spend time there?
Yes.
How long were you there?
I don't know, 2 weeks.
Did they recommend any follow-up treatment?
Yeah.
Have you been participating in that?
Haven't been able to. I was scheduled to go to CMH on the 24th of this month.
Okay.
My doctor was transferred to Blake Weimer in LaGrange, and I was scheduled to go to CMH on the 24th. Got food stamps started in LaGrange, got all sorts of cool stuff.
So this was all gonna be in LaGrange?
Yeah. But as Dan told me that we have some sort of like a 20-mile radius or something that I was still able to be there. Because it wasn't a certain range away from it or something. I can't remember what it was. So I didn't feel like I was breaking any laws by being in LaGrange.
So do you believe that you can continue this probation and complete your probation?
If given another opportunity, absolutely. I mean, the job is probably in question, but
Is there anything else that you want to say in defense to this probation violation accusation?
I thought I was doing okay, man. I was slow rolling it. Obviously, I had some issues to begin with, you know what I mean? The surgery and everything, waiting for that to heal up and then trying to find gainful employment. I kind of lucked into the Fawn River kayak job, but yeah, I was looking into the rule. And I had to stay clean for 30 days before I could pass a piss test to, a urinalysis. I apologize. A urinalysis to get a CDL, DOT policy. So I was kind of struggling with that, but then I lucked into the job in Fawn River kayak, and a buddy of mine had the job and he couldn't do it because of his injuries, and I could.
So is your injury now is fully healed that you had surgery for?
I don't know what capacity you would say fully healed, but yeah, man, I was working. I was pulling kayaks up a steep hill, and I was driving a van and backing a trailer into a driveway, and I was taking people, dropping them off, and launching kayaks down the river. I enjoyed my job, and I did a very, very awesome job, according to my boss. Really liked my, work ethic.
Okay.
Didn't have any issues working.
I don't have any further questions.
Ms. Davis?
Under the circumstances, I'm not going to ask him any questions at this time, Mary. Thank you.
All right, thank you, Mr. Hewitt. You can step down. Anything further, Mr. Gibson?
No, Your Honor.
The defendant was placed on probation in January. There was a large block of upfront jail time. This was originally charged as a felony, I believe. Resisting and obstructing and the domestic violence. As Daniel indicated, the probation hasn't gone very well. Some of it was the defendant's physical limitations, and some of it is just his state of mind. There is a PPO in effect that was issued by Judge Pattison, I believe, and there's a hearing coming up on that. And the defendant is credible in some regard that she keeps contacting him, but he's clearly aware that the personal protection order prohibits him from having any contact with her because he knows he was contacted by the police. They didn't do anything, which they should have, lodged him right away. So he continues to have contact, violation of the PPO. Judge Pattison will deal with that at the PPO hearing. He was given 112 days jail, I think, and he's got another 16 under his belt now. He hasn't tested. If he'd gotten connected with community mental health services, they would have paid for the testing. He hasn't done the domestic violence class. CPS was willing to pay for the class, and he didn't cooperate with them, so they didn't pay for the class. Time frames are unclear. He went to Detroit for a period of time, which I'm not sure we even knew that. Then he was in the hospital for some period of time. I believe he was. I don't think it was weeks, but we never had a release. So we can't just call him up and say, hey, what happened here? They won't disclose any of that. Then at some point he starts working. And I'm not sure that we learned about it till after the fact. So he didn't pay, which is the least of my concerns. But we had the opportunity for someone to pay for his testing, but he didn't cooperate with CPS, or he didn't cooperate with CMH, now Pivotal. We had someone that would pay for his domestic violence class. We didn't cooperate with them. He continued to violate his personal protection order, and it's alleged that in July that he assaulted Carly Harmon. This is a probation violation hearing, and it's a somewhat strange proceeding in that, one, hearsay is admissible. The rules of evidence don't apply strictly to a probation violation hearing. And two, the standard for the burden of proof is lower than a conviction. It's lower than proof beyond a reasonable doubt. It's a preponderance standard, I believe. I believe it's more than probable cause. So I don't have to prove beyond a reasonable doubt that you violated it, and I don't have to prove beyond a reasonable doubt through direct testimony. The hearsay is a little distant. It's secondhand hearsay. Daniel was told by somebody who may have been told by somebody, but they're clearly afraid of you, CMH and CPS. But I think your representation of some of that preceded the probation is probably accurate. Basically, once you got out of jail, we haven't accomplished very much, and you've been sort of on your own program. The recommendation was to just revoke the probation and impose the balance of jail. I guess some of the PPO facts are going to come out in the PPO hearing. Ms. Davis, do you have any further recommendation?
Your Honor, I just wanted to point out that in my notes at the time that he was sentenced on this and placed on the probation, the court was concerned about his ability to behave himself, I guess, basically, that there was concern about lifting the no contact, but that Ms. Harmon wanted the no contact lifted. That being said, that doesn't give him free rein to have contact with her if there is some other order of another court, whether it be the abuse and neglect court, or whether it be Judge Patterson's court through the PPO, which was issued according to the court records on 7/11 of 23, which would have been after this incident that's alleged on 7/6 of 23. Which was not ever turned into our office to review for any charges. So I was not aware of it until today. But certainly the incident that's alleged for August for the PPO violation, he is certainly aware that there was that. And his behavior before being placed on probation with CPS and with Carly and with Heather DeCastro, yes, some of that probably was before, but he earned it. And then after, since he's been out, he's continued and it sounds like escalated his assault over threatening behavior. With Mr. Frazine, he's been verbally abusive. We're all adults here. We can, take words, but his behavior is not that of somebody who wants help. His behavior is that of somebody who wants to make excuses and make himself look like he's in the best light, that he's, giving all of this money that he's making to Carly. Well, it's his own testimony is that Carly is also gainfully employed. So, he wants to put himself in that victim role, that he doesn't have the money to test and he doesn't have the money to do this because he's just giving. But in reality, if he is doing that, his priorities are out of line and he's being assaulted and threatening and abusive in doing that. So it's certainly not helping his overall situation. And if he would take the effort to get into the DV class that would be paid for by CPS and get into substance abuse counseling that would be provided by CMH Pivotal, he would learn these things. But he's not ready to learn these things. So at this point, I would ask the court to impose the balance of the year. Part of the reason I did not ask him any questions is because ethically, I don't feel it's appropriate because there is that PPO violation. And the notes in it when I pulled it up are that this probably should have been sent up as an ag stalking, that sort of thing. So he may have more charges coming his way, but he was given the option for probation with the knowledge that the recommendation was going to be a lot of jail if he didn't take this opportunity to better his situation, and he didn't. So I'd ask that the balance of the year be imposed. Thank you.
That is true. There was an understanding that there was a lot of jail hung over his head. Mr. Gibson, what's your thought?
Well, the defendant, to my knowledge, has been diagnosed with post-traumatic stress disorder, and that he does have, genuine mental health issues or concerns. It's my understanding that he did have a forensic evaluation. He indicated that he had been diagnosed with mental health problems and that he was on medication. One aspect of this case that made, I believe, things a lot more difficult for the defendant was that he had suffered a work-related accident prior to the arrest for this case. And so he was trying to go through rehab, and he had, it's my understanding, he had gotten addicted to painkillers as part of his the injury that he suffered. And so he was dealing with a lot of stuff going into this probation. So, I would ask the court to take all this stuff into consideration, because the defendant has, he has considerable jail credit. He served considerable jail time before he pled in this case. So I would ask the court to take that all into consideration, as the defendant has made definitely some efforts here, but he was dealing with a lot. He had a lot that he had to deal with that the typical defendant wouldn't have to deal with, recovering from a very complicated medical surgery and those kind of things. So thank you.
Can I speak again, Your Honor?
No. That's what your lawyer's job is.
Let's get to that.
The defendant is intelligent, but he does have mental health issues, but he's a gaslighter. He's making other people look like they're crazy and he's not. That they're at fault and he's not. And he's pretty good at it. And I don't know what Carly's circumstance is. I think there's some credibility in the defendant's statement that she's voluntarily having contact with him in violation of her own PPO, which certainly doesn't help her abuse neglect case. Defendant did some things, other things he didn't. First of all, I do find that the prosecution has established that the defendant has violated his probation. He's failed to complete or even start any of the treatment that was offered to be paid by CPS. He's failed to test, and some of that was offered to be paid for by Pivotal if he'd gotten involved with CMH. But then he did at some later point. There was this incident in July. I don't know why it didn't come in as a criminal complaint. I think Ms. Harmon was not cooperative. And I think that you can have looser rules of evidence in PPO hearings and probation violation hearings than you can in a criminal matter where it requires proof beyond a reasonable doubt. So I don't know what to make of that. Daniel's just saying, let's just put him away as long as possible and then he gets out. Not sure I like that option either, but I don't think I'm going to be any more successful this probation later than I am now. He has 112 days plus 16 days, which is 128. I'm going to order 180 days credit 128. Leaving, what is that? 52 days minus good time. Probation is continued. I can always revoke it or close it later. Because I want a better plan. I want a release. I'm willing to get off your back, Mr. Hewitt, but I'm not just casting you to the winds without any sort of plan. So we'll address this further. We'll see also what happens with the PPO hearing. That could be up to 90 days. You do have some credit. And we'll see what we could get with Lisa for some sort of CMH treatment. All right, you're free to go.
Thank you, Your Honor.
That's nuts. I need a hug, man.
Good morning, sir.
Good
Mr.
morning.
Hewitt, can you hear me?
Yes, I can, Your Honor.
All right, this is Judge Middleton, and we've met. Judge Pattison had you most recently, but I'm here with your lawyer, Mr. Paul Gibson. Also present is Joshua Robert from the prosecuting attorney's office. You've got two cases. File number 231828 alleges domestic violence on Carly Harmon on July 6th as a third offense, as a fourth habitual offender, which I think makes it punishable by up to life imprisonment.
Yes, Your Honor.
Okay. All right. And that one is alleged to have occurred on July 6th. Reverse. The other case is file number 231829. That is alleged to have occurred on August 14th in Constantine. And it alleges a continued willful course of continued or repeated continuous harassment of Carly May Harmon. And that's also charged as a 5-year aggravated stalking as a fourth habitual offender which I think makes it also a life offense. According to Mr. O'Bear, and I'm not sure I understood the exact terms of it, so why don't you repeat the current offer?
Sure, the offer would be to plead as charged in file 23-1828 FY, the DB third. And we would dismiss the entirety of file 23-1829.
That's
FY.
DV third as a fourth habitual?
Correct.
This is insane.
And then you would dismiss the stalking. According to Mr. Gibson, you're not interested in pleading to a life offense. And so you wish to have a preliminary examination in this matter. Is that correct, Mr. Hewitt?
That is correct, Your Honor. I'm pretty sure you've been following everything that's been happening. I mean, Carly's been in your courtroom how many dozens of times over this, you know what I mean? I've been in your courtroom a couple of times over this, so.
Yes.
Yeah.
All right. Now, we don't have the same witness in each case, do we?
Correct.
So we could do one of the preliminary examinations. Which one has the officer?
The DB third file has the officer who would be unavailable next week.
All right. And that is Philip Hopkins.
I wrote you a letter. I don't know if you got it yet, Your Honor.
I haven't seen it. Now, any letter I get from you, I have to share with the prosecutor and your lawyer. So I haven't, if it hasn't made it to me yet, but I'm gonna set the prelim in the aggravated stalking for 9/7/23 at 1 o'clock. I find good cause to continue the other case. I'm gonna set prelim in the DV case
Excuse me, Your Honor.
for 9/14/23 at 1. Yeah,
You said you find good cause what?
to adjourn the matter for 1 week because the officer has a funeral and his father passed. So we'll do the prelim on the July case. No, we'll do the prelim on the August case, and the July case will have to be 1 more week. We can address bond after next week's hearing.
Excuse me.
Is there any way that you can?
I see him on 9, the month of 9.
I'm sorry. Yeah, got it. Make that 11. November 7th, not September. All this month I've been confabulating my months. And I thought once we got past October and I quit saying August, I'd be all right. Now I'm saying November and September. So at any rate, your prelim on the stalking case, 231829. Theoretically, we'll be next Tuesday. We have just a terrible afternoon. We have a lot of cases set, including a bad child criminal sexual conduct case. But we'll do the best we can. The other case, stalking.
That's disgusting. Well, Your Honor, how horrible what you're talking about. I don't mess with kids, man. I don't
Well,
do that.
it's not, you're not charged with that.
Neither
It's
you're
another
neither,
person.
I know.
So
I don't even
unfortunately,
like to hear about it. I was really
tried-
hoping that you would see through the bull, and I was really hoping that you would dismiss these cases so that I could.
Well, I'm not
Continue
clairvoyant.
with my life.
I don't know what happened, and I can't just read a police report. We will actually take testimony where people will testify under oath and make a record and see whether there's probable cause to believe crime was committed and you didn't. When I hear testimony, I'm in a better position to make a decision whether there's merit or not. But I can't just do it because.
No, what I was gonna say is since July, we've been in your court, both me and Carly, and she has literally said to you, like, she didn't feel the same way. All this stuff stems from
All right,
last
well,
year.
don't say any more about it. I understand. I've seen a bunch of both of you, but I didn't make the charge, the prosecutor did. And so, then you also had the PPO violation in Judge Patterson's court. So we'll hear some testimony and then I'll be in a position to make a decision. Mr. Hewitt, why don't you come up and have a seat? Good afternoon, sir.
Good afternoon, Your Honor.
Here. Trevor William Eugene Hewitt.
Yep.
Of course, we've met. I just need to make sure I identified you for the record. You have two matters going on here, and we're going to deal with one of these to free up your probation agent. And then we'll address the preliminary examination. Daniel, why don't you come up to the podium if you would? This is a probation violation petition that was filed in file 221963FY. It's a misdemeanor. It's reduced to domestic violence and attempted resisting and obstructing. The defendant was placed on probation in January of 2023 on those two misdemeanor offenses. The allegation is that you violated your probation by violating a criminal law of any unit of government, failing to report on a monthly basis, failing to abstain from fines and costs, failing to pay fines and costs. You did abstain from paying fines and costs and failed to abstain from the use of alcohol and drugs or take a test on demand. And he also alleges that you failed to participate in treatment as directed. His recommendation.
Your Honor, I think we discussed, that was made a while back and
Yes.
per our discussion, I think I was just asking for time served because he has several days credit if you add them all up and just close the probation, revoke it at this point.
All right.
I think I have, since this original charge of 112 days, I think I have another 86 days. If my math's right, 65 in October and then 21 in August on other charges.
All right.
Related charges.
Mr. Hewitt, you have a new charge, which we're about to start addressing here in a few minutes. You're not on probation on that charge, but you're on bond. The earlier probation, because of other issues and previous violations, has resulted in 186 days in jail. Originally, he was recommending that I imposed a very large jail sentence, but he ended up doing a bunch of jail in the meantime. So your probation agent's recommendation, if you acknowledge that you got a new criminal charge or failed to report or failed to do treatment, he would simply recommend we revoke this probation and leave the new case to stand on its own merits. Do you understand?
Yes, Your Honor.
Now, Mr. George does not represent you on the probation violation. He's here with you on the other case. The original lawyer on the earlier cases was Mr. Gibson. In order to prove that you did violate your probation, we'd have to have a hearing. And you would be entitled to have an attorney where they'd have to show by a preponderance that you did violate your probation. However, you could also simply admit the violation and there would be no need for a hearing. What would you like to do, Mr. Hewitt?
Well, I've already spoken with Dan and the revocation and time served is probably what's best for me. I got a lot on my plate, as he mentioned. You know, I got a case upstairs and I got this case today, so.
Yes, you're on bond in circuit court, you're on bond in district court.
Yeah.
And as far as what we're gonna do as a probation, we've probably taken it as far as we can. So do you acknowledge that, I don't know if you've been convicted any of the new offenses, that you failed to report and failed to complete your treatment as directed?
Yes, Your Honor. I really would have liked to have gotten into the DV program, but it just,
hurdle after hurdle, and then I was in jail repeatedly. And like I talked to Chelsea Myers about starting it, and she said, don't start it because you got a lot going on right now. And if you start it and you don't complete it, then you only get one shot at it. So I never got to start it.
All right. Other than what I said to you about Daniel's recommendation and my intention to follow it, did anybody promise you anything to get you to plead to this
No,
or threaten you?
no.
You've already exceeded the statutory maximum on the domestic violence charge. The resisting and obstructing charge does carry up to a year. Or 186 days jail. Right at 186. I'll wipe out whatever financial obligations are left. Your probation is revoked. Successful. All right, thank you, Daniel. Mr. Hewitt, let me take these files out. The only thing that remains is your aggravated stalking complaint, which we're gonna address. Ms. Davis, the people ready to go on that?
Warner, we need to address a bond violation in this case before we go any further. We are prepared to start the preliminary examination.
All right, well, let me take these files out and we'll be back and address our attention to this matter. Let's go on the record in the principal case set for today, which is file number 232254, People versus Trevor Hewitt. In that matter, the defendant is charged with aggravated stalking. The allegation is that on October 4th of 2023 in the village of Constantine, that the defendant did engage in a willful course of conduct involving repeated or continuous harassment of Carly Harmon. The conduct being such that it would cause a reasonable person to feel intimidated, threatened, or harassed. Said conduct actually causing Carly Harmon to feel intimidated, threatened, or harassed. And at least one of the actions consulting in the offense was in violation of a restraining order the defendant had been on actual notice of. That is a felony punishable by up to 5 years imprisonment and a fine of up to $10,000. And a minimum probation of not less than 5 years. Defendant is also charged as a fourth habitual offender, making that, I believe, a offense punishable by up to life imprisonment. As Mr. Hewitt said in the previous record, he kept doing things to end up in jail. This matter was authorized by the prosecutor on November 29th. And was signed by Chief Thayer of the Constantine Police Department on December 5th. Defendant was arraigned by Judge Pattison on December 12th. That's not right. At any rate, Judge Pattison adjourned the matter from December 12th to December 26th. I was gone that day and it got adjourned again on December 26th. I can't tell exactly what happened. On January 2nd, we were here and I made a record. The defendant was not here. There was a signed stip from the prosecutor to adjourn the preliminary examination. I think somebody was unavailable. Matter was continued until this date. Defendant was on GPS tether. The matter is set for preliminary examination today. So somehow it morphed over from Judge Patterson's docket into mine. And here we are. Bond in this matter is set in the amount of $1,000 surety. As defendant indicated, he was on probation for domestic violence and attempted resisting and obstructing. There's a personal protection order in effect, or there was, and he's bound over to the circuit court in another matter. Ms. Davis, what's the status here?
Thank you, Your Honor. Your Honor, the people became aware of a bond violation today at the courthouse, and the corrections officer, Vincent Bailey, advised that after I spoke with Ms. Harmon and she walked outside, Mr. Hewitt decided to go out there with Ms. Harmon, or in the area of Ms. Harmon, and the corrections officers saw him communicating with her outside of the courthouse, which is a bond violation. He signed the bond conditions stating he would have no contact whatsoever with Carly Harmon. There are 2 other cases pending upstairs with her as the victim, and he has been in jail multiple times for these issues with having contact with her, threatening, intimidating. He's had significant mental health issues. And at this point, we're prepared to start the preliminary examination, but we would ask that the court deal with this bond violation first, such that Ms. Harmon is not very cooperative at this time, likely due, what we believe is to the continued contact with Mr. Hewitt. So I'd ask to have his bond canceled pending the outcome of the prelim. We can start the prelim today, but I'd ask to continue it to another date so that I can speak with Ms. Harmon again. Thank you.
Mr. George, what's your position?
Your Honor, we would be prepared to move forward today. We've reset this. I know the first time was because of my trial calendar up in circuit court, and I believe Officer Crew was unavailable for a period of time, and that's why we had adjourned it to today. My client's ready to get this going, get this over with. He's had this matter as well as the other 2 matters upstairs hanging over him. I know that I understand what Ms. Davis had just said. Obviously, I was not there. I didn't say anything myself. But what I would say is I know it does always put clients in an awkward position when there is some type of active bond condition or PPO in place and then they're in the same place. So I don't think that it's appropriate at this time to cancel my client's bond. I think an admonishment from the court would be sufficient. I think he's aware of what type of conduct is acceptable and what conduct is. Thank you.
Well, he certainly is. And he told me as much. I'm going to continue to see her no matter what you say or do.
Afterwards, yeah.
What?
After this is all done and over with, I mean,
All right. Well,
it's gonna be a long process, Your Honor, but I do plan on reconciling with her. I saw her outside, but I didn't talk to her. It's.
all right. Well, don't say any more about it.
Yeah.
All right. Stop. There may be video or something we could review. It would also be a violation of your 2 circuit court cases, but I don't have jurisdiction over those. And it just happened. So Ms. Davis hasn't had an opportunity to file any bond petition in the circuit court. But where we are right now is you're prepared to start the preliminary examination, but you're not clear whether you can complete it without the cooperation of Ms. Harmon. She's been hot and cold. So the question is, am I canceling a bond on a case that isn't going to get bound over? But let's go as far as we can here, and then I can make a decision on what to do with the bond. And you may want to view the video and see what that shows. Can you, Michelle, ask them to cue that up? Is there any of it on video?
I believe there is video. I asked them to
All
preserve it.
right, thank you. All right, then let's begin the preliminary examination, the matter of People versus Trevor William Eugene Hewitt. This matter's been kicked the can down the road for weeks and weeks. Mr. Hewitt, I believe, was here every time. On the original day, on the Tim George attorney conflict day, on Max Kuhn conflict day, and so today is the day for the hearing, and he always expressed that he wanted to have the hearing. So let's see how far we can go, Ms. Davis, and then we'll address the bond further.
Thank you, Your Honor. People will call Officer Max Kuhn.
Good afternoon. Do you swear or affirm any testimony you're about to give in this matter will be true to the best of your knowledge and belief?
I do.
Thank you. Please have a seat and state your first and last name for the record.
My name is Max Kuhn, Maxcoon.
Officer Kuhn, where are you employed?
Employed with the Village of Constantine, the Constantine Police Department.
And are you a police officer?
I'm a police officer. I've been employed there for almost 7 years.
And were you on duty on November 7th, 2023?
I believe so, yes.
And I guess going backwards, had you been made aware that Carly Harmon wanted to have police contact on or about October 4th, 2023?
Yes, I would received. I'm sorry, can you restate that question?
So did you have contact with Carly Harmon?
I did have contact with Carly Harmon before, yes.
And tell me about that.
I received a dispatch complaint for regarding a welfare check, where the caller informed dispatch that he was concerned for Carly Harmon, or the call was concerned for Carly Harmon. I arrived where I met with Carly Harmon and another male individual there. After speaking with her, they said everything was fine. And at that time, she informed me that she received multiple phone calls from a number that I don't recall the number off the top of my head, but she received multiple phone calls from a specific number.
And where did you make contact with Carly Harmon at?
I made contact at her apartment on 200 Meadow Lane.
Is that in the Village of Constantine?
It is.
And that's in St. Joseph County, Michigan?
Yes.
So after speaking with Carly, did you have anything else further in the investigation?
Regarding the welfare check, no, there's no concern for her welfare. The phone number that I had previous contact with her where I understood that Mr. Hewitt had a no contact or PPO violation. I received the number that she gave me from her telephone, and I contacted dispatch, and it matched the same number that she had received multiple times. And looking more into that, while I was speaking with her at her apartment, she informed me that Mr. Hewitt was.
Your Honor, I would object as to any statements that she made at that time.
I'm not sure where he's going with this. I can maybe clarify the question. Were you standing with Miss Harmon at this moment that you're talking about?
Yes.
For getting a phone call?
Yes.
Okay. And without saying what she said, what did you observe? Did she receive a phone call while you were there?
I can't recall. I have to look at my report.
Okay. And you mentioned Mr. Hewitt. Who was that?
That was a boyfriend at a previous time that I know.
Had you had contact with Mr. Hewitt and Ms. Harmon previously?
Previously, yes.
And the person that you believe to be Mr. Hewitt, is he here in the courtroom today?
Yes.
And can you point out what he's wearing and describe him for the record, please?
He's wearing a dark color hoodie, glasses, black brim.
Your Honor, may the record reflect he's identified the defendant?
Yes.
Thank you. Did you do any checking on whether there was a personal protection order protecting Carly Harmon?
Yes.
And what did you find out?
I checked our law enforcement information network, and I was informed through that there was a personal protection order protecting Carly from Mr. Hewitt.
And as part of the conditions of that personal protection order, was there a prohibition from him appearing at her home or calling or contacting her?
Yes, I believe it was a no contact, not to contact her.
Based on what you found out from Ms. Harmon, did you go and speak with Trevor Hewitt?
At a later time, I did, yes.
Okay, was that on 11/7 of 23?
I believe it was.
Okay, and where was he when you had contact with him?
He was lodged at the St. Joseph County Jail.
And tell me about that contact.
When I met with him, he agreed to speak with me, and after reading his Miranda rights, I brought up the call that took place on October, and he informed me that it was him that was calling.
And so he admitted he was calling Carly Harmon?
He admitted that he called dispatch regarding the welfare check, and that phone number matched a phone number that Carly showed me that had called her multiple times.
And did you ask Mr. Hewitt about why he was calling?
I did.
Well, I'm a little confused. So was it Mr. Hewitt that called Central Dispatch and asked for the welfare check of Ms. Harmon?
Yes.
All right. So he acknowledged that he made that call?
Yes.
Did he acknowledge that he called Ms. Harmon?
Without reviewing my report, I can't say off the top of my head.
Your Honor, may he review his report?
Yes, he should have reviewed his report before he ever showed up here to testify.
Is your memory refreshed?
Yes, it is.
All right, and so what do you know about Mr. Hewitt's calls to Carly?
When I asked him if he had spoken to Ms. Harmon, he mentioned that he speaks to her all the time.
And did you ask him to elaborate on that because there's this PPO?
Yes, he told me that he was going to always contact her and that he didn't give a fuck what the law says.
Did he continue on talking about his case with her? As in, had he had any other contact besides just phone contact with Ms. Harmon?
Oh, he said that he was released from Bronson Behavioral Health Hospital. And once he was released from there, he went to stay with Ms. Harmon.
And so he indicated that he went to her apartment after he was released from the mental hospital?
Yes.
When was that?
When was the date that he went?
Yes.
That I'm not sure of.
Well, approximately when?
It was going to be after October 4th. The welfare check came from, the original call came from the Bronson Behavioral Health Hospital.
And so just to clarify, the calls to Ms. Harmon were also from this Bronson Behavioral Health
That's correct.
number? And Mr. Hewitt confirmed that he was the one talking to Ms. Harmon from the hospital?
He confirmed that he called Ms. Harmon from the hospital, yes.
And then his statement to you was that after he was released from the hospital, he physically went to Ms. Harmon's apartment?
That's correct.
And what apartment is he talking about?
The apartment at 200 Meadow Lane, apartment number, I believe is 14.
And did he indicate that he knew that there was a personal protection order in place?
Yes, he was aware. I'm the one that served it originally to him prior to this incident.
No further questions at this time.
Good afternoon, Officer Kuhn. How you doing?
Good afternoon.
You indicated that you served the PPO, Mr. Hewitt?
I served, I believe it was a PPO. There's a confusion between the PPO and bond conditions at the time, but yes, I served him informing him that he was not allowed to see Ms. Harmon. And I gave him a copy of the order.
Do you believe that that was a bond conditions for a criminal case, or do you believe that that was a PPO?
It was a separate incident. I'd have to look at that actual case to see exactly which one, but I believe it was a PPO.
Were you able to review the actual physical PPO itself?
At that time, prior to this event?
Prior to this case? Yeah.
Yes.
Okay. Do you know that if you were the one that served it?
I did serve it, yes.
Okay, all right, just want to clear that up. So when you you met with Mr. Hewitt where? Where'd you
Prior
meet
to
with
this
him?
event, sir, or
In November?
in November at the St. Joseph County Jail?
Okay, do you know what he was in custody for?
At that time, I don't know exactly why he was there. I know that he had an upcoming case that day that he mentioned.
Okay, did he advise that he was represented by counsel in that case?
He did not. I did read him his Miranda rights and he agreed to speak with me.
Okay, were you able to check with jail staff to see what the circumstances of any case that he had at that time were?
I did not speak to them about any upcoming cases.
So you were just able to find out that he was in custody at the jail, is that right?
Correct.
And then interviewed him at the jail, is
Yes.
that right? Didn't really inquire about what the circumstances of his being in jail were, but read him his Miranda rights, is that right?
He was in custody, so yes, I read him his Miranda rights.
After November 7th, did you have any further contact with Mr. Hewitt?
No.
Okay. I don't have anything additional, Your Honor. Thank you.
Go ahead.
Sorry, I was
Sorry.
making sure that you were ready. Officer Kuhn, when you spoke with Ms. Harmon with this welfare check, can you describe her demeanor or what her reaction was?
She seemed, when I first appeared, she seemed confused as to why I was there regarding the welfare check. She seemed overwhelmed, frustrated.
And as far as her being
Let
frustrated,
me stop you for a minute. This is, I guess, form of swatting. He calls from Bronson Behavioral Health and says, I need a welfare check on Carly Harmon. What was at jeopardy with her welfare? When you got the dispatch to go there, did you get any information on what it was you were checking on?
According, the caller claimed that when he calls Carly Harmon, that another male snatches a phone from her hand, and that he was concerned for her well-being.
All right. Do you know if those 911 calls were preserved?
I did receive a copy of the 911 call, yes.
Oh, thank you. All right, that gives me a little more context. Thank you. Go ahead.
what was your understanding of Ms. Harmon's relationship with the other male individual that was at her apartment when you went for the welfare check? If you have any understanding of it.
I don't know anything about her personal life. She didn't seem to be in any distress, and she didn't indicate if they were in a relationship or not with me.
And regarding the calls that she had been receiving from Mr. Hewitt, do you know how many calls and how close in time they were?
I do not. She showed me her phone just by providing and showing it to me like such, by putting the phone in front of me. And I saw multiple numbers, but I didn't count how many, and I wasn't able to obtain a copy of all the logs.
And what would you describe Ms. Harmon's reaction to these calls?
Frustrated.
Do you remember what time of day these calls were coming?
I was dispatched at in the morning, so I can't tell you exactly what time these calls were made, but according to her, I believe that they were made that morning or somewhere, but I don't have anything that says that.
No further questions.
Anything further?
No, you're not.
Thank you, Officer Coon. You can step down.
Thank you.
Do you have any other evidence to present at this time?
Not at this time, Your Honor.
All right, you're asking for an adjournment?
Your Honor, I would like the opportunity to speak with Ms. Harmon again when she has not had contact with the defendant.
She is here pursuant to a
She
subpoena?
was here pursuant to the subpoena. I don't know if she's still here or not.
Do we know whether she's still here?
She's gone.
She left
Yes.
with your permission, or she just got mad and left?
Well, there was some confusion because we talked before and then there was the bond violation and then we did not get to speak after that.
Bond violation in circuit court,
In this,
this case?
in the parking lot.
All right, well, so she was here today
Yes.
and this was set at 1, so you saw her sometime during the lunch hour?
I saw her about 5 minutes to 1, I would say, and spoke with her.
All right, and then she left?
She went out, yes, Mr. Hewitt was in the hallway and I walked out with her. And then she went outside and Mr. Hewitt went inside. So I guess, I mean, as an officer of the court, obviously I can tell you what I believe would be shown on the video and from the
Well,
statements, but
I'm not unwilling to continue it. The issue is he's gonna sit in jail if you get what you ask for. In the meantime, I don't know how far you got with the witness. I guess your contention is that she was here ready to testify. Mr. Hewitt went out and talked to her and she left before you ever got a chance to speak to her.
that's not accurate. I
Well,
did
was
speak
she
with her.
willing to testify here today?
She was going to get on the stand if I asked her to get on the stand. And there was concern because of the hostility and her issues with contact. She was not in a good place today to be able to testify. And then with his behavior.
Well, I
after
wish she
spoke
hadn't
with her.
left. I mean, she was here under subpoena and then she just drove away.
I think that there was, I guess, I don't know how much I can really get into on the record, but the concern was that she wasn't going to testify truthfully today because she was angry and had had contact with Mr. Hewitt.
Who was she angry at?
The system. Her rights were terminated to her child.
I'm aware of that. So at this point, she's not particularly cooperative in any of these pending cases.
Correct.
She did get a personal protection order and there were allegations of domestic assault. As you know, the defendant was on probation for domestic assault and he acknowledged a domestic assault. Then she would continually reconcile, or I'm not sure what the right term is, his testimony as he got out of the hospital and went back and stayed at her house while the PPO was in effect and while bond conditions were in effect to prohibit contact.
No, there was no bond at the time, Your Honor.
All right, correct. Then that may be accurate. Then that resulted in some of the other charges. She did testify at least one previous preliminary examination. Have you seen the video?
No, I physically walked outside.
Yeah, why don't you go take a look at it, you, Mr. George, and see what it shows, and then I'm not unwilling to grant you a continuance. The question is, do I cancel his bond? I guess I want to know what happened. So let's take a recess. You guys can go view it and then we'll see what we need to do.
Thank you, Your Honor.
Can I speak freely, Your Honor?
I'm not unwilling to talk to you, Mr. Hewitt, but your lawyer's not here. You and I have always been able to speak to each other in a
Yeah.
civil manner, but I don't want to talk to you without your lawyer being here, so. Let's wait a minute and see what they can tell us.
I just wanted to let you know that like
But don't say more about it.
no, I'm not talking about the case right now. I'm just saying like I'm making steps in my life to better myself, man. And
Well, I'm all in
I've been
favor
staying
of
on a
that.
friend's couch for right now, but things are looking up for me and, you know, I'm trying my best.
All right.
I really am. Like my lawyer said, man, it's really hard seeing her here and
All right, hold
it's
up.
just. I want to be one of them couples, you know, 50 years from now, looking back on this.
All right, well, that's
I
probably,
really hope so.
let's just hold up.
Can I use the restroom?
Yeah, go ahead.
Awesome.
Keep an eye on things out there. I don't want to have any other issues. We didn't think you were leaving, but. All right, we're back on the record. I tried to check the circuit court status of the cases upstairs. And the system's been broken for 5 months and I can't get into it. I just sent a frustrated email. Because this happens to me all the time. There's another way to do it, but it's much more cumbersome. So I don't know the status of the defendant's bound over cases. We have returned, the prosecutor had given some preliminary evidence regarding a violation of the defendant's personal protection order. In fact, the officer testified that he was there when the calls were received. Defendant acknowledged to him that he made the calls. Defendant acknowledged he went back to that address and Officer Kuhn was aware a personal protection order was in effect because he had served it on the defendant. And the defendant was aware the personal protection order was in effect. The parties were going to go view the video of something that transpired earlier this afternoon. Ms. Davis, did you have an opportunity to do that?
Yes, Your Honor.
What does it show?
Your Honor, the video shows me walking Ms. Harmon out past security. Mr. Hewitt was in the hallway at that time, seated. And after she walked out, and I stood there for a moment to make sure she made it outside without being bothered by Mr. Hewitt.
Why did you walk her out?
Because Mr. Hewitt was sitting in the hallway staring at
Well,
her.
why didn't we put her back in your office or something?
Your Honor, she did not want to cooperate, and it seemed very clear that it was based on her continued contact from Mr. Hewitt. I knew I wasn't going to get anywhere with her at this point, and I needed to talk to Officer Kuhn, who was in the back. Not even a minute from when I stepped away from the security desk, Mr. Hewitt went outside the same way that Ms. Harmon had gone. And on the video, there's two separate videos from the angle. He was speaking with her, and Corrections Officer Bailey went out there and saw them having communication, although they were standing probably 10 feet apart, perhaps trying to look like they're not having communication. So at this point, he has contributed to the unavailability and hostility of this witness, which is the key witness in all of his cases. And the testimony that has been provided thus far in this case, probable cause purposes, maybe it's enough to bind over. Was it threatening, intimidating, harassing behavior? We don't have her here to say that today at this point, but it was a direct violation. It was knowingly a violation by Mr. Hewitt. And he's so brazen to do it today while we're all here at the same courthouse. I don't know what else to do. If the court's not gonna bind it over without her testimony here, then I would ask to
Well,
have some
all right,
time.
there's enough probable cause from the testimony of Officer Kuhn to believe that he violated the restraining order. I'm troubled in that she was never going to testify today regardless of what happened, because she had already been released, or I'm not sure, but she was leaving. She wasn't going to come in here, and I wasn't going to have an opportunity to speak to her. So she never was going to testify. And I'm embarrassed that they were able to have contact with each other out in the hallway.
It wasn't in the hallway, it was outside.
No, I believe you said he was sitting there staring at her in the hallway.
Yes, he was.
Well, that,
As you're aware, there is a window into our waiting room
oh,
that has a
okay, so
direct
she
value.
was in your waiting.
She was in our waiting room,
Oh,
yes.
all right. Well, that's better. And then at some point she got up and walked out of your waiting room?
Met with her back in my office and we discussed the case and what's going on. And she then walked out and I saw him still sitting there. And so I walked with her out past security and waited until she walked outside. And then I walked back in to go talk to Officer Kuhn. And within 2 minutes, Corrections Officer Bailey was coming in saying, you need to know that they're having contact outside.
Officer Bailey, would you come up to the podium, please? Right there. Good afternoon. Would you state your name, please?
Vincent Bailey, sir.
Please raise your right hand. Swear or affirm any testimony you're about to give in this matter will be true to the best of your knowledge and belief.
I do.
Officer Bailey, you are a sworn deputy assigned to a bailiff duty in this court, is that correct?
Yes, sir.
And other courts here in the courthouse. You've been present when Ms. Davis was relating to the court what happened. Did you see the defendant follow the witness, Carly Harmon, out into the parking lot?
I did, sir.
All right, tell me what you did.
I was actually coming in from bringing some individuals from the jail to here. When I came in, I was given instruction to go and find, I'm sorry, I forgot your last name.
Ms. Davis.
Ms. Davis, because there was notice of those two conversating through the cameras. So I went to find her to let her know what I was instructed to pass on.
So did you actually see them talking out in the parking lot? I just saw it through the camera.
Once I made contact with her and we walked outside, the individuals were roughly 10 feet apart diagonally. Did I see them verbalizing at that particular moment? No, but I did view the footage and you can see Ms. Harmon? Ms. Harmon, where she was standing, you could see her verbalizing, but she was standing by herself. Then you have to look at the other camera angle. And the only person she could have possibly been talking to would have been Mr. Hewitt.
All right, thank you. Mr. George, you have any questions, or Ms. Davis?
No, Your Honor.
All right, thank you. Mr. George, what's your position? I guess a couple issues. Are you moving to bind based on the testimony you have? Or are you asking to continue the matter? And then if so, well, yes, I'll ask that.
Your Honor, I'm asking to continue the matter so that I can speak with Ms. Harmon and hopefully secure her attendance at a future hearing.
All right, Mr. George.
Thank you, Your Honor. Well, I did have the opportunity to review the video. Obviously, there's no sound. There are two different cameras and you can see the two individuals outside on the same side of the building. In viewing the video, one of the things that I'm having trouble with is Ms. Davis had indicated that It's my client that is causing her to not want to cooperate, not want to be here. But, and maybe I viewed it once, so please afford me a little bit on that. But from what I understand, she's outside, she's smoking a cigarette, and she's texting, and then it ends once she gets picked up by a vehicle. Obviously, that wasn't driven by my client, so it looks to me like she was leaving. So, I think that, my argument would be, I don't think there's been anything that's established that my client was doing anything to try to prevent her from testifying today. I think that we need to have a hearing and probably need to hear from Ms. Harmon if we're going to take the step of taking my client's liberty away and putting him in custody until we have the second part of this preliminary examination.
Good thing we got a lot of time because we don't have anything else. All right, let's do a little history lesson. In file 221963FY, Mr. Hewitt was charged with resisting and obstructing police officers and domestic violence. That is the case that the defendant was on probation on, that was the subject of probation violation hearing earlier. The defendant did 186 days of total jail in that case. That incident alleged to have occurred on October 4th of 2022, and he was charged at that time as a fourth habitual offender. He entered a plea to attempting to resist or obstruct a police officer and assaulting Carly Harmon. He was placed on a probation, which included a number of things, including no contact with Carly Harmon. And a record was made earlier today where that probation was revoked. Next in line is file 231829. That is a aggravated stalking case and fourth habitual offender alleged to have occurred in August of 2023 in the village of Constantine. And the complaining witnesses, investigating officers, were Chief Dan Thayer and Max Kuhn. We had a preliminary examination that was began on November 7th. And it was continued until November 14th. And there was an issue about who or when the probation officer, when the PPO was served. But on that day, the preliminary examination was finished. It was established the defendant had been served with a personal protection order. The matter was bound over to the circuit court on November 14th. Bond was $5,000 cash or surety and had not at that time been posted. I believe once the defendant was bound over to circuit court, at some time that bond was posted. Now, bear in mind, the incident in that case is alleged to have occurred on August 14th of 23. The incident in this case was October 4th. The defendant was bound over on November 14th. There was another felony case, 231828. In that case, it was a domestic violence case and charged as a third offense. And that allegedly occurred on July 6th of 23 in the city of Sturgis. And we were dealing with that on October 31st. It was a plea offer. Defendant declined. We set the prelim for the stalking case for November 7th. It was continued. We set the prelim in the domestic violence case for November 14th. And Ms. Harmon did testify, and the defendant was bound over on November 14th. So we had a domestic violence that allegedly occurred in Sturgis on July 6th. It took some time to get that matter to court. That prelim was held on November 14th, and the defendant was bound over to the circuit court. And the next incident in time was the August 14th incident of stalking. Preliminary examination was held in that matter. Ms. Harmon testified the defendant was bound over to the circuit court on November 14th. The next incident in time is this incident, which October 4th. Officer Kuhn went to the sheriff's department to talk to Mr. Hewitt, according to the affidavit, on November 7th. And then he submitted it for a warrant on November 29th. So the prelim had been held on November 14th. This got submitted to the court in early December. And I would note in every one of these cases that I've mentioned, he has a no contact provision as part of his probation. He has a no contact provision with Carly Harmon as a part of the domestic violence case from July 6th. He has a no contact provision from the stalking complaint of August 14th, and he has a no contact condition in effect from the incident of August 4th. So the matter was bound over after preliminary examination on those two cases on November 14th. We took testimony, I recall it. Very close time after that, there was a hearing in the family court, in which case Ms. Harmon lost custody of her child. In fact, lost parental rights. In part because of all of this. So, and so did Mr. Hewitt. That's as hard as it gets.
Yeah.
And so at that point, then this case got adjourned a couple of times, once because Mr. George was in trial, once because Officer Kuhn was unavailable. There were the holidays, and now here we are. And the indication would be as of October 4th, he was violating the conditions of his bond and his probation. And as of today, he was violating the conditions of 2 circuit court bonds, 1 district court bond, and 1 district court probation. And the defendant is bound and determined to have a relationship with Ms. Harmon. I don't know which side of the line she's on at this point, but the court looks pretty foolish when we keep ordering not to have any contact from a personal protection order, from a probation order, from a bond in a stalking case, from a bond in a felony domestic violence 3rd case, and this new stalking case from October 4th.
Your Honor, can I speak?
No. So
She tried to get rid of people.
I'm offended by that. It makes us look foolish. But I'm also offended by bullying you into some sort of a plea by locking you up. Because I don't think she's gonna cooperate 2 weeks from now any more than she did now. But I also believe there's probable cause to support a bind over based on the testimony that I heard today. Mr. George, if you want your client to speak, I'll hear him. If you want him to not, I'll defer to anything else you have to say.
It's just. I went outside. Can't help but look at it from her perspective, with everything going on.
I hate that she's going through what she's going through. I hate it. I did want to say something. Can I just, Your Honor, when I spoke to David Tomlinson, he said that I was awarded a visit with my son. And if I made bond, that I would have a visit with my son. I've been in contact with Heather yesterday, and I have to talk to Chelsea Myers about doing a scrapbook for my son and possibly seeing him one last time before he goes up for adoption. And I just want to say, if like my bond is canceled, I can't do that. And I'll be right down the street, and I'd actually have an opportunity to get to see my son, maybe take some pictures of me and him for the scrapbook. It's really big. Even though they say he's been gone so long that it would be pointless of me seeing him, I still want to see him. I don't think that's a good reason that he's been gone too long. To hug my son would be really awesome.
I didn't review the record of the family court case, but I do believe that your rights were terminated because you failed to comply with all these bond conditions and personal protection orders. There are multiple allegations that you were assaulting her, and she declined to stop contact with you, which resulted in the termination of your parental rights.
Yeah.
That's about as sad as it gets. So I'm going to continue this preliminary examination until January 30th at 1 p.m. to allow prosecution to present additional evidence. Bond is canceled.
Do what?
It's canceled. You're going to jail.
Why?
I don't want to argue about it. I'm not happy about it either.
It doesn't help anybody though.
No, it doesn't.
It doesn't help me at all. Your Honor, please.
Please remove the defendant from here. I don't want to argue
I got
about
a
it.
backpack over here.
Might be not gonna cost me a problem right now.
No.
Thank you, Your Honor.
Your Honor, is there,
Julie,
please, is there a
come on,
chance?
we gotta go.
The answer is no.
She got my attention out there, man, and
Yeah,
You
you,
are
I
what am I
just,
supposed to do?
I just got your attention also.
Trevor. You don't want him to add one
I'm
month.
trying to dig a hole, man. I'm just trying to stay out of jail and see my son.
He has dug a hole. As I indicated, he violated a personal protection order, a probation condition, 2 felony bonds, and this bond. Ms. Davis, if you're serious about this, you'll be filing petitions to revoke his bond in the circuit court.
Yes, Your Honor.
We have some things to talk about as we go through the week. We do have some preliminary examinations scheduled for this afternoon. And don't know yet what the status of those is. And the prosecutor is short-staffed. They're down to 2 people. They need a staff of 5. So we're going to have to be dealing with some of those issues. I mentioned that the prosecutor's office is down to 2 staff. While I was gone, Miss Deborah Davis is no longer with the county prosecuting attorney's office. And I'm not sure everything that has been transpiring. You're going to hear about it sooner or later. So they're down to just Mr. Marvin and Mr. O'Bear, the chief assistant, trying to cover 4 courts. Have hired somebody else, but they won't be starting until March, as I understand it.
I didn't realize taking on a part-time job to help out at the prosecuting attorney's office would lead to me realizing that it was an area of the law that was my passion. Taking it on as a full-time position meant giving up some of the freedoms of being self-employed. It was an adjustment to be under the control and direction of someone, especially when both of us were new to prosecution. I dove in headfirst to training, learning, and trying to be the best possible legal advocate I could be. I handled hundreds if not thousands of cases in a short period of time, from civil infraction formal hearings to capital felony cases that resulted in decades of incarceration for some of the most unspeakable crimes against children. We often were understaffed, including for the majority of 2023. I took on a lot of extra work, but it only increased my desire to excel in prosecution. Handling the hardest cases with the most egregious facts was my specialty. I have never been too scared to try a case, or to ask for more investigation to be completed so that I could give each case the attention it deserved and determine how justice could best be served. I'm sure I didn't always get it right, as we only know what we know. No person can know all of the facts, history, and potential consequences of any case. However, I respected the officers and their opinions, and made sure to fact-check as much as possible before making any decisions. I have never taken my oath to uphold the law and seek justice lightly. I understand complex trauma, and how it affects the ability of victims to make rational decisions. I dedicated my career to protecting those that can't or won't protect themselves, as well as the ones who have gained the strength to face their abusers. I've had to make some unpopular decisions, but I've always done so with integrity and compassion. I knew that announcing I was going to run for the office of St. Joseph County Prosecutor in 2024 would be controversial, but I could not have ever imagined what some people will do or say to serve their own interests. I talked it over with trusted family and friends, and decided that even challenging the incumbent resulted in losing my current position. It was something I felt strongly about. My family and kids supported the decision. They are my top priority, and this process is going to have an effect on them no matter how much I try to shield them from the harsh realities of politics. I have dedicated the last 3.5 years of my career to serving this community as an assistant prosecutor. I look forward to a couple decades of being able to serve you as the elected prosecutor if given the opportunity. The facts are the facts, and they will come out in due time. I appreciate those that have reached out, and I look forward to running a clean, successful campaign for the Republican Party. I will always put honor before ego, and strive to build a prosecutor's office filled with 5 well-trained, knowledgeable, and dedicated attorneys who will work together as a team. My leadership philosophy is to surround myself with colleagues that challenge each other to be better for the service of the citizens, and raise each other up with respect and honor. I look forward to a new chapter, and can't wait to get back to being an advocate for justice.
Mr. Peterson, you may proceed.
Thank you. This is a pre-hearing conference that's being held pursuant to Michigan Court Rule 9.115 F4C, and this is being convened virtually by Zoom video conference, and the hearing is being held before the Kalamazoo County Hearing Panel number 3 of the Michigan Attorney Discipline Board. And this is in the matter of the grievance administrator versus Deborah J. Davis, whose P number is 70843. And this is case number 25-5GA. The hearing panel is comprised of David Peterson, and that's me. I'm the chairman. And we have Catherine Humphrey, an attorney from Plymouth. Can you see and hear all of us, Attorney Humphrey?
I can. I noticed that my video, at least, is a little bit jumpy, and that may be because of my Wi-Fi, but I'm hearing and seeing fine. Thank you, Mr. Peterson.
That's quite all right. I noticed that when you signed in originally, but I figured it was probably just a little bit of a technical thing. And the other member is Attorney Gail Town of Kalamazoo. Attorney Town, can you see and hear everyone?
I can, thank you.
And Attorney Davis, can you see and hear all of us?
Yes, sir.
And Attorney Blessing Nelson, can you see and hear all of us?
Yes, I can. Thank you.
All right, great. The panel's been appointed by the Attorney Discipline Board, which is the adjudicative arm of the Michigan Supreme Court for the discharge of its constitutional responsibility to supervise and discipline Michigan attorneys. The counsel for the grievance administrator is Attorney Austin Blessing Nelson, who will present the case for the Attorney Grievance Commission, which is a separate branch of the Michigan Supreme Court for the investigation and prosecution of disciplinary matters. We'll now proceed with the hearing, and we have verified that Attorney Humphrey and Attorney Town can see and hear everyone, which is great. And Attorney Blessing Nelson and Attorney Davis can also hear and see everyone. And the court reporter is ready to go and has been recording, and that's Brad Hall. Good morning, Mr. Hall. Okay, I want to just a couple little housekeeping matters. If it's necessary for anyone to go into any kind of confidential communications with anyone else, or even someone that's not on that you would want to confer with, the case manager, Jody Groh, will be handling that, and it should work out all right. So I am been doing this for a while, and I usually am pretty informal, and we go along and get along. If anybody has any questions or wants to say something, feel free to chime in. And we do have to talk kind of slow and give people a chance to speak, because we don't want to have a lot of voiceovers. But you can feel free to do that, and I certainly won't be offended, and I don't think anyone else will either. Let's start out by witnesses. I received
Actually, Ms. Davis and I had a chance to talk on Friday, and she is intending to retain counsel. And in light of that, I haven't mentioned this particular part to her, but in light of that, I would suggest that we actually basically adjourn this pre-hearing so that she has a chance to retain counsel. They have a chance to review everything, and that we have a chance to, set dates and everything, taking into account her attorney's schedule.
Absolutely. We want to certainly do that. I guess I would say the things that we want to go over if we adjourn, and it seems to me to make sense. If we adjourn, next time we're going to want to go over, witnesses and exhibits and all the usual things you do in preparation for most any kind of a hearing. So, Attorney Davis, is it your intent to hire counsel?
Yes, Your Honor.
And do you know who you're going to retain?
No, we're still in discussions with the county about coverage and how that's going to work. But I do have some names of individuals that I will be speaking with.
Okay, all right. Well, that's good. Attorney Town, is there anything you want to add?
No.
Okay, and do you agree to an adjournment?
Yes, I do.
Attorney Humphrey, how about you? Anything in particular you want to offer?
Only that I think we would find it helpful to get an appearance as soon as possible. I also think we would be well advised to set a date for the adjourned pre-hearing conference so that everybody has a goal to be working towards.
Oh yeah, I almost never adjourn a case, whether it's in court or a procedure such as this, without a date certain, because That way everybody knows we're not wandering in the dark here. So let's take a look at your schedules. I'll just happen to have mine right at hand. And what do you think, Attorney Davis? A couple of weeks or so to get your attorney on board?
Not certain that a few weeks is going to be sufficient. There's been back and forth with different insurance and professional liability policies, so I would ask for at least a month. My witness list is already started. There's about 22 people so far, but there's probably going to be a few more. I don't know.
I would suggest at least 60 days. Not only does that give her attorney time to get on board and review everything, but it would also give us time to discuss any potential for a consent resolution, get it before the commission, all that takes time. We don't want to, have to adjourn this more than once. I would suggest at least 60 days.
Well, I was looking at 30, but when you said the magic words, a consent resolution,
I figured you'd love those words, so I said.
Those are my favorite words in this situation. Let me look here. I'm looking at, let's see, March, April, May. I'm looking at May, and the week of May 19th, I've got to be, I'm going to be at a conference, so I can't do that. Memorial Day weekend, is that week going to be too crowded for anybody? Otherwise, we're into June, and I can live with that if I have to.
With the exception of Memorial Day, I should be available the week of Memorial Day, the 27th through the 30th. Or I'm also fine June. I can live with that too.
I'm sorry, I didn't mean to interrupt you, Mr. Blessing Nelson. I just want to say I will be en route traveling starting starting on the 21st of that week, but I would be available on the 19th or the 20th if that worked.
I can't do the week of the May 19th. I've got to be at a conference.
You said that, and I apologize.
No, that's all right.
I think I will be out then the whole following week because I'm en route and there and then en route back.
Okay, so now we're stretched into June. Now that's golf time, so don't be too crowded here for me. I'm open. I'll just throw out some dates. I'm open June 4th, 5th, and 6th.
I have a doctor's appointment the morning of the 6th, but the 4th and 5th are fine. I also hope to have this resolved before we come back. So.
Attorney Town, how do you stand on June 4th or 5th?
I do not have the 4th available, but the morning of June 5th I have available.
How about you, Attorney Humphrey?
June 5th morning or afternoon is fine.
And how about you, Attorney Blessing Nelson? Is June 5th okay?
Yes, it is.
And Attorney Davis? Okay. Ms. Grow, would that be agreeable with your office? Let's pick. I hate to start in the middle of the day, but let's pick 10 o'clock in the morning. That's half the day's gone already.
That's fine on her end.
10 o'clock's okay with everybody?
Yes, sir.
Yes.
And it's okay
Yes.
with you, Ms. Grow?
Yes, sir.
Okay, well, sounds like we have a consensus. Very well. At the request of the respondent, or maybe it's a joint request. I don't know.
If it needs to be attributed to someone, I would certainly take that. I'm not sure. Mr. Blessing Nelson and I talked about how Usually there's just one adjournment permitted, so it certainly can be on my side.
All right, well, I'm pretty flexible about that. We'll call it your side.
My position is I would say this isn't an adjournment because we didn't adjourn today's hearing. We're just setting another hearing. So my argument would be it's not an adjournment, and if a future adjournment requested, that rule wouldn't be triggered, but that's just the petitioner's position.
Very well, we will continue this hearing without adjournment. We stand in place here, but we'll pick it up on June 5th at 10 a.m. And Ms. Grow will send everyone a new notice. And I think that concludes everything we need to do today. I want to thank you all for promptly signing up and showing up. And I'll be thinking of those two magic words, consent resolution, Attorney Blessing, that you mentioned.
No guarantees, of course, but we will discuss the matter and try.
Excellent. Okay.
I want to say that we have been engaging in discovery back and forth. Mr. Felicity Nelson, I can't open some of the things that you had sent to me, and I know you couldn't open some of mine. So we'll have to probably reconvene and get that figured out.
Well, you know, I hate to say this, but being old school, you could use the United States Postal Service. They do fairly well. And if you got trouble opening and closing things electronically, which I have sometimes myself. So if you got a lot of time, let's put it that way.
Yes, he sent over a USB drive through the Postal Service, but we may have to do paper copies of some of these for some reason. I don't know why the PDFs aren't opening, but we will continue diligently getting that done.
Okay, very well. We are continued to June 5th at 10 a.m.